Hi everyone, this is Attorney Lilian with Lily Legal, and I am here today with our immigration chat. So today I will be talking about waivers. 601 waivers, 601A waivers. These are for misrepresentation, unlawful presence, and for other immigration violations. Okay, so that's what we'll be talking about today. So if this is your first time joining, feel free to like my page, subscribe if you're watching on YouTube, and share this if you find it helpful or if you know someone that this will be helpful for. Okay, so again, I'm Attorney Lilian. I am an immigration lawyer based in Worcester, Massachusetts. However, I have the privilege of representing clients all over the US and all over the world using the US immigration system to get them status for themselves and for their family members. So, thank you for joining me, and we are going to get right into waivers. When they apply, how how you get to the point where you need to apply for a waiver, what the requirements of a waiver is, and how you can put your best foot forward when you are applying for waivers. Okay, so that is our topic for today. If you are watching this on Peace TV, hi, welcome. Thank you again, Peace TV, for streaming my live on your page. If you have any questions, please feel free to put it in the comments. Again, this is a chat. I want to communicate with you. I want you to be able to ask me your questions. It can be about immigration waivers, or it can be anything else immigration related, okay? So I am here for you. So when do you need an immigration waiver? Right? This is one of the biggest questions that people ask. What is a waiver? Do I even need it? Is USCIS making a mistake when they tell me that I need a waiver? So typically you need a waiver if you are unlawfully in the US, if you came into the US without authorization, and you are filing through a spouse, you would need a 601A waiver to basically ask the US government to forgive the fact that you came in without authorization and you stayed in the US for a period of time. You would also, so this is the waiver, it's called a provisional waiver. So you get the waiver, you leave the US, you go to your interview, and then you come back. So it's a whole process of how do you even know that you need the waiver. So typically, most people, okay, unless you came in without authorization, most people will not know that they need a waiver until they go to their immigration interview. So the waivers that I'll be talking about today is specifically related to misrepresentations. So that's when either you're filing for a green card or you're filing for a visa to the US and you put incorrect information, or in some situations, maybe you lied in order to get into the US. If that's your situation, you got a visa because you lied, that's called misrepresentation or fraud. So depending on how USCIS sees your situation, they might require you to file a waiver in order to basically ask for forgiveness for the misrepresentation. Okay, so typically when a client comes in, I am basically checking off a list to make sure that they will not need a waiver. If they need a waiver because they came in without authorization, we start working on that right away, because regardless of if your spouse is a US citizen or not, if you came into the US without a visa, without parole, some form of um, um, some form of authorization from the US government saying that you can legally come into the US, you are going to need a waiver. Okay, so that is bottom line. If you're filing through a spouse and you did not come into the US with a visa, parole, or other forms of authorization to legally be in the US, you are going to need a provisional waiver. Okay, so if that's your situation, typically when you come into me, I run down my list, and if that's your situation, you will know before you leave my office that you will need that waiver, and we'll start already talking about whether you qualify, what makes you qualify. Okay, so the next category is people that, like I said before, had any misrepresentation or fraud. So this can apply to anyone, right? Whether you are applying through a spouse, a child, a parent, it does not matter. If you had any sort of misrepresentation in your immigration history, if it comes up, you will need a waiver. Okay, so that's just something to keep in mind when I'm talking about waivers. Those are the two that I'm specifically focusing on for today. There are other categories that you would need a waiver for. We will be here all day if I go through each category. So let's focus on the provisional waiver, people that came in without authorization, and then people that had misrepresentation in their immigration history. Okay, so that's going to be our focus. So for people that had misrepresentation, typically you wouldn't know this until your interview, right? I try to pull information from people, but sometimes people forget, or they don't disclose all their history to me. And then we go into the interview and it comes up. And if it comes up at the interview, the officer will give an opportunity for you to file a waiver. So last week we talked about notice of intent to deny. Okay, so part of a notice of intent to deny in these type of situations where there was a misrepresentation, the officer would basically say, we want to deny your case because you have a misrepresentation, but we're going to give you the chance to file for a waiver. And your response to that, if that's the only thing that the officer finds wrong with your case, and the reason that they want to deny your case, your response to that notice of intent to deny will be proof that you filed the waiver. So it is it's one of those situations that you really wouldn't know where the officer is going to when the officer is going to ask you for that, unless we know ahead of time that you had a misrepresentation in your immigration history. This can take place in the US or if you're at the consulate. So if you go to your embassy interview and they find in your immigration history that you have any sort of misrepresentation, then you can file, they will basically refuse you the visa with the option to file for the 601 waiver. Okay, so that's really how those two happens. Let's see, we have a question. Let me just put that up. In a situation where you brought your child without putting his or her name on the DS-260 and got denied from getting citizenship, can you apply for waiver and will you be granted? Okay, so this is a different situation. So I'm guessing in this situation, you already have a green card. If you're filing a DS-260 for a child, you already have a green card. And when you got your green card, you did not include your child. And then you're trying to apply for citizenship and you were denied because you did not include your child on your when you got your green card. Now, in some cases, if you truly did not know that you had a child when you were filing for the green card application, and you can provide proof of that, the USCIS will typically, right, might go ahead and still approve your case because you had no knowledge. So this misrepresentation and fraud that I'm talking about is for situations where you know that it's a misrepresentation. So you know that you have a child and you did not answer the questions on your DS-260 correctly. those are situations that are clear-cut misrepresentation, okay? If you know, if you had a child with someone and you didn't find out that the person was pregnant and that they had a whole baby until after you came to the US, that's a completely different situation. Now, can you apply for a waiver at the citizenship stage? No. Okay, so the 601 waiver is really at the green card stage that you're applying for that. You can, right? So in some situations, if you are put into immigration court, there are certain waivers that are specific to immigration court that you can apply for. So that's really that's kind of the situation someone in that situation will find themselves in, is if you do not end up in immigration court, you will just keep your green card status, but you will not be able to file for your child. Unless you are put in immigration court, your waiver is approved and you're able to retain your green card, then that will take care of the misrepresentation. But the 601 and 601A waivers specifically is for the green card stage, right? For people still trying to get a green card to the US. Okay. Let's see. The question is, how does my boyfriend from the Philippines find a job in Ohio to be near me? So he would have to apply, right? How does he find a job? He will have to look for one and find an employer that's not only willing to hire them, but willing to file a petition for them to legally work in the US for that company. So it's a whole process, but it's not impossible. It just will require a company that's willing to go through that process with him. Okay. So now let's talk about what you actually need to provide, right? What you need to qualify for either the 601 or the 601A. You need a qualifying relative. A qualifying relative. So what does that actually mean? Okay. It means you need a spouse or a parent that's a US citizen or permanent resident. That's your qualifying relative. Your kids, even if you have US citizen children, they are not qualifying relatives for a 601 or a 601A waiver. Okay. So you need a US citizen or permanent resident spouse or parent in order to file a 601 waiver. And then the next requirement is that that qualifying relative has to have extreme hardship, right? You have to show that they will suffer extreme hardship if you were not allowed to stay in the US. So it's a two-part situation. So you're showing that your US citizen spouse or parent or permanent resident spouse or parent is basically going to suffer extreme hardship if you, the non-US citizen, non-permanent resident, is required to leave the US. And you can also show that they will suffer extreme hardship if they leave the US with you. So it's not only that they are staying in the US while you're out of the US, but you can also show that if they were to go to your home country with you, that they will suffer extreme hardship. Okay, so that's the basics of it. And we're going to get into more details. I'll do other videos with more details on breaking down what a misrepresentation is, when what you say or do is not technically misrepresentation, and all of those things. But today, if you have already been found inadmissible to the US and you fall into and it's because of a misrepresentation, that's what we're going to be covering today. Okay. Now, if you are in this situation, you need you need to basically prove the hardship. That's the biggest and most stressful part of the whole thing. If you cannot prove that your spouse or parent will suffer a hardship if you're not in the US, then your waiver will not be approved. Sorry, that's just how it's really that basic. Is you have to be able to document the hardship so that USCIS can look on paper, because you're not having an interview for the waivers. Okay, that's really want to make that clear. For the 601 and 601A waivers, you are not going to have an interview for it to be approved. It is all paperwork. It is all what the officer is looking at, reading. They get to decide based on the documents that you send in whether your spouse or parent will actually suffer a hardship. It's a very wide requirement, because what is extreme hardship to one person might not be to another. Basic separations that happen just because you're in two different countries, basic hardships that happen because you're in two different countries might not be considered extreme enough to get you the waiver. Okay, so what has been considered extreme hardship? That's what you want to know. So let's cover that. What actually counts as extreme hardship? So medical conditions, right? That is a big deal. So if you have a spouse or a parent that has a medical condition that requires them to get specific treatments, and that treatment is not available in your home country, that's a hardship that you can build on, right? That's a starting point. If you have a spouse or parent that, you are their caretaker, they have a medical condition and you're the one that takes them to that basically takes care of them and their medical needs. You take them to their appointments, you are the one at home with them, taking care of them, and you not being there will greatly affect their quality of life. Those are things that we can really build on when it comes to extreme hardship. Again, there's no hard and fast rule of this is extreme hardship, right? I can't tell you that, every single medical condition counts as extreme hardship. Again, it's up to the officer, but the main thing is putting your best foot forward. You don't want to get to a place where you have sent in an application and now and your application is not strong enough and it gets denied. You can reapply, but depending on what applications you have that's pending, you might end up in immigration court while you're doing all of those other things. So it's really important that you pay attention and that you gather as much documentation as possible for your waiver application. Okay. So now, I said before that children, whether they are US citizens or permanent residents, do not count when it comes to the waivers. However, when it comes to your US citizen spouse being away from their children, if they decide to move to your home country with you, or when it comes to the hardship they will suffer if you're not there to help them take care of your children, that can be brought in as part of the hardship argument. But again, just hardships to your children alone is not going, if you don't have a spouse or parent that is a qualifying relative for you, is not going to lead to you being able to apply for these waivers. Okay. Again, if you are just joining me, please feel free to leave your questions in the comments. It can be about waivers. It can be about any other immigration questions that you may have. This is Immigration Chat with me, Atty Lilian, and I am here every Friday at 12 o'clock Eastern Standard Time to answer your questions and to bring you some information, okay? So that's what we do here. So if you have any questions, please feel free to put them in the comments. If you are watching this on the replay, please feel free to put your questions in the comments. I always do go back and respond to you. So please feel free to do that as well. Okay. So the reason, I just want to backtrack a little. The reason that I wanted to do this topic today is because in my practice, I have a client that their waiver just got approved, right? They didn't do anything wrong, but USCIS saw that as a misrepresentation and required a waiver. It was a lot of work on their part emotionally for the family to basically be able to apply for this waiver. And so today we got notification that it was approved, which basically made my day. And I wanted to basically come and do this live because I want people to know that just because USCIS says that you had a misrepresentation or that you're here without authorization, so you have to leave for your before you can get status, does not mean that you can't get status. There are things like those 601 and 601A waivers available to you that if you qualify, you will be able to gain status. Okay, so that's really the reason that I wanted to do this video today, because I just want to give people hope that just because you are accused by USCIS of misrepresentation does not mean that's the end of your case. Okay, there are options available to you, and I just wanted to do this live to basically let you know what those options are and how you can qualify for it, and basically, give you some hope if you're in that situation. And if you're not in that situation, basically give you information that might help you one day or help someone else that you may know. Okay, so we have a question from Angela. Let's see. What criteria are they using to accept or deny expedite cases after aging out? Okay. So this is a interesting question because I'm trying to understand the context of the expedite. So I'm guessing you're talking about at the embassy, right? Because just from your question, I'm guessing you're talking about getting a case expedited, but you're saying after the person ages out, not before. So that's a little tricky. They're looking at, in order to expedite those cases, they're looking at how soon the person will be aging out, what their ability to gain status, after they age out, and how the aging out process would affect their ability to get a green card. So I would need more information to really answer your question. So feel free to send me a message or reach out for a consultation. But yeah, I would need more information in order to properly answer your question. I'm sorry. I know that's not what you want to hear, but I just would need more information. Okay. So now we're going to talk. We've been talking about the 601 waiver. We're going to talk about when you're going to need a 601A waiver and what that actually entails. So the 601 waiver itself is either, like I said, it's either you're applying for it in the US, you came in with a visa and you had some misrepresentation or some other issues, you're applying for a green card through a spouse, parent, what have you, and you are now at your interview stage or pre-application and you know you're going to need the waiver and you're applying for that in the US. Or you are outside of the US, you just had your interview, the officer accuses you of misrepresentation, refuses you a visa, and requests that you file a 601 waiver. So that's when those two applies. A 601A waiver is very different from those. So the 601A waiver is specifically for people that have unlawful presence in the U.S. Okay, so unlawful presence, and typically, right? Typically, this is people that came in without a visa, a parole, or anything of that sort. So if you are in that situation, you would need to. So typically, if you don't have a legal entry into the U.S., you will have to leave the U.S. in order to gain a green card. But if you leave the U.S. without a waiver, depending on how long you've been in the US, you most likely will have to wait outside of the US like 5 years or 10 years or 3 years, depending on, again, how long you've been in the US at a status. So because of that reason, the waiver is really your way of getting back into the US without waiting whatever that penalty period is. So you apply for your relative petition, your I-130s, you apply for that. And once that's approved, then you can apply for the 601A. Once that's approved, then you can leave the US. Once your interview is set, you can leave the US, go to your interview. Again, the 601A waiver is specifically for unlawful presence. If you have any other thing, if you have misrepresentation, if you have a criminal history that would lead to you being inadmissible, the 601A does not solve that. So if you are in that situation where you're going to have to apply for a 601A waiver, but you also have misrepresentation in your history, what's going to happen is if you don't know this until your interview, that's when the real issues happen. So you go to your interview, you have your 601A waiver, you think, go to the interview went well, come back in. However, if you go to your interview and there's a issue of misrepresentation, then you will need a 601 waiver, because now you're outside of the US, you are post-interview, and the officer that interviewed you is saying that you had misrepresentation. So that would lengthen the amount of time you have to spend outside of the US. Depending on the hardship in your family, you might be able to expedite your 601 waiver so that you'll be able to come back sooner. But it's really important to know the difference between the two. The 601A is only for situations where you basically situations where your only inadmissibility issue is that you came in without authorization. If that's your only issue, you did not have any misrepresentation, you don't have any other issues in your immigration history, you are able to use that waiver, go to your interview. Once you're approved, you can come right back to the US with your visa. So it's really important to know the difference and know when each one applies. Okay, so Angela's clarifying her question. So just to be clear, the beneficiary has aged, okay, and the beneficiary requested for an expedite. The case is still at MVC. So yeah, okay, so if you've requested an expedite, you would really just have to wait for that. If their age is locked under CSPA, then their age is locked, right? So they're not really aging out, right? If I just want to make sure that we're clear on that. So if you're saying that their age is already locked under CSPA and the case is already at MVC, your expedite is really for the interview, and you would have to meet whatever requirements for an expedited interview. So the aging out is not the issue here if it's already locked. There are situations where aging out will lead to an expedite, because the CSPA does not apply. So if the CSPA already applies in your case, most of the time you wouldn't really need to do anything else. But again, like I said, it might be best to just schedule a consultation just so I can really dig deeper and see what's going on with your particular situation. Everything I say on here is for informational purposes only. I can't give you legal advice. So that's really the thing on that. I can't give you legal advice from my end. I can only give you information. So if you do want more specific advice on your situation, I would just suggest reaching out to me, and we can set that up. And thank you so much, Angela, watching all the way from Kenya. Well, welcome. I love seeing people watching this from all over the world. Like I said, with what I do, I represent clients from all over the US and all over the world. So I am happy when I see you all watching. Again, if you have any questions, I am talking to you about 601 waivers, what you need to know, and how to apply for it and put your best foot forward when you are applying for that. If you have any questions, even if you're watching this on the replay and you're like, wait a minute, I have a question for Lilian, put it in the comments and I will respond. I always go back and respond to all your questions, so please feel free to do that. And if you are watching this on the replay and you are watching this from outside of the US, just put your location in the comments. Like I said, I always love seeing where I'm reaching, and I love what I do. So the more people that I'm reaching with this information, the happier I am. Okay. So let's talk about how you can be eligible for a 601 A waiver. Right? So you must be, in order to apply for a 601 waiver, you have to be at least 17 years old or older, right? And you must have an approved petition for the 601A. You have to have an approved petition. So that's either an I-130, an I-140, which is the employment side of things. And even if you are, if you're selected for the diversity visa program, so the visa lottery, you can still technically apply for the waiver. But again, you need the qualifying relative that's going to be either a spouse that's a U.S. citizen or permanent resident, or a parent that's a U.S. citizen or permanent resident. So in situations where people, so someone out there will be asking, if you already have a parent that's a U.S. citizen or permanent resident, why don't they just file for you? Why do you have to use the DV lottery? Well, I can answer that for you. So if you are a married child of a U.S. citizen, for example, you are not, the time frame for you to actually get a visa to the U.S. is quite long. So if you are able to get a lottery, if you're able to win the lottery, but now your only issue is that you need a waiver, you still have your U.S. citizen parent to file for you. In the other way, if you are a married child of a permanent resident, your parent cannot even file for you, okay, until they become citizens. So how does the 601 waiver help you if you win the DV lottery? You will be able to win the lottery and still have a permanent resident parent for a qualifying relative that will then file the waiver for you. Okay, so it's really important that even if you are applying for the DV and you're in this situation where you might need a waiver, depending on your particular situation, you might still be able to qualify if you have a U.S. citizen parent or a U.S. citizen spouse or permanent resident. So it does not, the limit here is that it has to be a parent or spouse. Children do not count. Okay, so that's really the downside of this particular waiver, is that even if you have your children that are now US citizens, let's say you're outside of the US, your child is now a US citizen and they want to file for you to come to the US, but you have filed for visa applications in the past and you put in incorrect information on those applications. Now you want to file to come to the US through your child, and and that application, your previous applications are now coming up and showing as misrepresentation for US immigration officers. You're going to need a waiver. And if the only family member you have in the US is your US citizen child, unfortunately, you would not be able to apply for this waiver. But if you are a child and your parent is a US citizen, you'll be able to get this waiver if they have extreme hardship. Now, I'm just going to tell you one thing, one tip that I do with my clients to help them with the waiver. Because most of the time when I'm talking to my clients or people in general, they do not see the hardships in their lives or the things that will change extremely when their partner is not there, or when their child or parent is not there. So one of the biggest things I do with my clients, and it's a tip that I'm going to give to you guys free of charge, right, is to get a psychological evaluation. And listen, I'll be the first that I'm Nigerian. Going to therapy, going to all of that is not part of our everyday thing, but it needs to be. And sometimes you don't know what you don't know, right? You don't know, sometimes you don't have the emotional intelligence to know how certain situations are going to affect you. But a therapist that's trained in this will be able to pull those information from you by asking you specific targeted questions about yourself, your family, your background, um, basically everything about your life, to come up with a report that basically showcases how the separation from your family member will affect you, right? Will affect the qualifying relative. That's what, like, again, that's the core of your application, is how will the separation affect your qualifying relative, and how would um, would you and your qualifying relative leaving the US affect your qualifying relative? Okay. So it's basically making an argument both ways, that especially for spouses, right? If I'm forced to stay in the US while my spouse is forced to be outside of the US, this is how I'm going to suffer extreme hardship. If I had to leave the US with my spouse because I don't want us to be separated, this is how I will be, how I would suffer extreme hardship. So those are, that's my tip, is to definitely be open to getting a psychological evaluation, because it is going to help you realize what hardships that you can suffer, and it helps me in making the arguments to USCIS on what you will actually experience, what emotional hardships, financial. We go into all of that. Okay. So if you are in this situation and you need a waiver, you have to be open to talking about your life, and really breaking down what are the financial components of your life, right? What are the emotional things? What are the medical situations that you have going on that will be greatly impacted if your spouse or your child was required to leave the US. So in some situations, parents live with their child, and if their child was to leave the US, they will essentially be homeless, especially if the parent is not working. Okay, so those are hardships, but we won't get there until you're willing to have those conversations. Okay, so Again, I really hope you got a lot out of this, because I just want to give people out there hope. When USCIS comes to you and says you need a waiver, that's not the end of your case. That's not, that doesn't mean that you will not get a visa or that you will not get your green card. It just means there's an additional hurdle that you have to go through, but it's not impossible. And that's really my message to you today. It's a hurdle to you getting your visa. It's a hurdle to you getting your green card, but it's not impossible if you follow, if you put your best foot forward. It's not impossible. So feel free, as always, to like, share, or subscribe if you're watching in a place where you can subscribe, and put your questions in the comments, especially if you're watching this on the replay, because I really want us to continue engaging, and I want to really make sure that I am getting you information. Okay, so as always, this is Immigration Chat with me, Atty Lilian. We are live every Friday at 12 p.m. Eastern Standard Time, and I cannot wait to see you next week for more Immigration Chat. Thank you so much. And if you want to schedule time personally with me to talk about your particular case, please feel free to do so. My information is on the screen and in the description. Okay. Thank you, and have a great rest of your day. Have a great weekend, and I will catch you next Friday. Bye for now.